Welcome to Nuts and Bolts of Arbitration, Employment Arbitration. I'm Belinda McCauley, Executive Director and CEO of the Beverly Hills Bar Association. And I'm delighted to be here today to introduce our speakers, Stephanie Cubacha and Kristine Kwong. Stephanie is the Vice President of Employment of the American Arbitration Association International Center for Dispute Resolution, based in the Los Angeles Regional Office. She administers large, complex cases, assists with recruiting panelists, and promotes the AAA-ICDR's mission and vision through outreach and education. Prior to joining AAA, Stephanie practiced family and immigration law in the Chicago area. Kristine Kwong is a senior partner at Musick, Peeler and Garrett LLP in Los Angeles, where she specializes in employment and labor law. With more than 30 years of experience, Kristine advises and represents clients in matters involving discrimination, harassment, retaliation, disability accommodation, wage and hour, and executive employment contracts. She is also an experienced neutral investigator, mediator, and hearing officer in workplace and civil disputes, and serves as an arbitrator for the Employment and Consumer Panel with AAA. Prior to joining her firm, Kristine held positions at several prominent other firms and has served as an expert witness in HR and accommodation cases. And now let's get started learning from these experts.
All right. Well, thank you so much, Belinda. Thank you all for joining. My name is Stephanie. As Belinda had stated earlier, I'm going to go ahead and share my screen to get started on our presentation. Okay. So what is arbitration? Briefly, it is a form of alternative dispute resolution. So it is similar to court in that there is a binding decision made by a neutral fact finder, but it differs in a lot of ways from court. Arbitration is a creature of contract for the most part, and it is a party-driven process. So here, if two parties sign a contract, and in an employment case, it's an employee signs an employment agreement with an employer, or their handbook, and arbitration is listed as where disputes are going to be heard. Then this would be where they would come to us or a different provider or ad hoc, which I will define later. And the parties get to choose the arbitrator and work with that arbitrator to set the hearing and the discovery schedule and, motion practice, what that could look like. And for arbitration, for employment arbitration, you will generally, as I stated, get into arbitration through either an employment agreement, which has an arbitration clause, or if you are an executive and you signed an individually negotiated contract, which does vary from just a general employee handbook. And then, Kristine, can you talk to us about the types of claims that are commonly brought in employment arbitration?
Sure. Thank you, Stephanie. So when you file a claim and you start a claim in the employment process, there are a lot of common claims that are typically raised. One are wage and hour claims and single plaintiff PAGA claims. So you might have cases where a plaintiff brought a representative and a single PAGA action in a court of law, and the defendant filed a petition to compel arbitration of just the single plaintiff aspect of the PAGA claim, and the Superior Court will stay the representative aspect of it. So you might get single plaintiff wage and hour actions with the PAGA claim, and also your typical employment discrimination claim. So things such as discrimination, retaliation, and harassment, those types of whistleblower claims. And sometimes you might even get a trade secret, confidentiality, breach of confidentiality, trade secret theft case. It really depends on what is listed in the arbitration agreement and what the parties agree to as to what types of claims would be subject to arbitration, but those are the general ones.
So here we have laid out a typical employment case arbitration roadmap. So from day 1 to potentially day 420. And just so everyone knows, one of the hallmarks of arbitration is that it is supposed to be, and usually is, faster than going to state or federal court for a case. But as you'll see, some of these timelines can vary, especially when we get into information exchange or discovery. So at the beginning stage, you have the filing and initiation. That's where you file your demand with the ADR provider. And that's when the fees first start to be billed by the ADR provider. So in California, there's a small fee paid by the employee and then a larger fee paid by the business. And pursuant to statute, the business has 30 days to pay that. And so we'll move on. Let's, from day 1 to 15, that's what that beginning stage looks like. We assume everybody pays. That we're not going to yet talk about the kind of objections you receive at the beginning of a case, or if somebody doesn't feel like they've agreed to arbitration. We will discuss that later, but this is just assuming that everybody's on board. And then approximately at day 15, the parties will engage in the arbitrator selection process. And as we'll discuss later, that can vary based on the contract, how well the parties and their counsel are getting along, and whether there's any disagreement as to where the arbitration hearing is going to take place. Assuming that we are able to get a mutually agreeable arbitrator pretty quickly, or within at least the first, generally under the AAA rules, it's about 14 days once we send an arbitrator selection list. Then we get into scheduling and holding the management conference or preliminary hearing. So at the preliminary hearing, which Kristine will go into detail about later, this is where you meet your arbitrator and the parties really kind of flesh out the timeline for the remainder of the case. And one of the things that they'll discuss at that management conference or preliminary hearing is information exchange and preparation, also known as discovery. So this is where the case can either really, this is where the rubber meets the road in terms of how quickly are the parties going to be able to get this done. Consistently, one of the biggest complaints that providers or anybody who works in arbitration hears is arbitration takes almost as long as court, or there's a lot of discovery and it's supposed to be efficient. And that really is going to depend on how well counsel is working together to get that information exchanged, and what the contract or the arbitration clause looks like before you get in there. And we'll talk about that more, but it can be, if it's a smaller or less complex case and there isn't as much discovery needed, the employee only worked for the employer a couple of months, then hopefully this stage goes a lot quicker. But if we're talking about a 30-year employee or an employee who was a senior executive for some time, then this part can take longer. Let's say we have everybody's pleased with the amount of discovery that each side has given, and they're ready to proceed to the hearing. Then we have the evidentiary hearing, which is akin to a trial in state or federal court. And that's where the parties present evidence to the arbitrator. After the hearing, then we go into post-hearing submissions. Not all cases will have them. So again, when you're talking to your arbitrator at your management conference, that's when usually it's determined what or if any post-hearing briefs will be filed at the conclusion of the hearing. And then you'll usually you can talk about it at the hearing or during the management conference about how many days you'll need to file your post-hearing brief, and are there going to be page limits? And usually there are, because that really does help condense everything. And then, at least under the AAA rules, the arbitrator will have 30 days from after the last submission for the post-hearing briefs, or if they've determined they have everything that they need, they'll have 30 days to render an award. At the bottom of the roadmap, it does talk about the expected costs. Those, again, will vary depending on the complexity of the case and how much discovery is needed, and if there will be, dispositive motions filed, and if there are a lot of discovery disputes. Discovery disputes tend to help or have arbitration become very costly very fast.
Yep.
Okay. And so, Kristine, if you can talk to us a little bit, both in your background as an arbitrator and advocate, how arbitration is different than litigation.
Yes, thank you, Stephanie. So one of the things for those of you that litigate in federal and state court is that there are rules to litigation. So in Superior Court, everybody follows the Code of Civil Procedure or the Civil Code. There are rules with respect to the discovery that you are able to propound, which is very open, subject to any type of protective order. And the same is true in the federal court as well. You're governed by the federal rules of civil procedure. And in arbitration, it's a little bit less formal, and the parties have actually more say on how they want to litigate their case, subject to the arbitrator making a decision on areas of disagreement. But one of the key aspects that is different is that the parties actually get to select their decision maker. So in comparison to federal and state court, once you file that complaint inside the judicial system, it will be assigned to a judge. For example, complex wage and hour class action cases, there's a group of judges in Superior Court that are designated to handle those complex cases, but you don't get to choose who the person is that will be deciding and managing your case. But in arbitration, depending on your arbitration agreement and how it's written, the parties have some say in who they get to select. So the more exposure and experience you have in arbitrating cases, you will get to know the available arbitrators that are in your community that will be deciding your case. The other issue is that arbitration is confidential. So your arbitrator does not disclose the proceedings, the award is confidential, and especially things like remote, it's all confidential. Um, Third is there's reduced discovery and motion practice. And what I mean by that is one of the key tenets of arbitration is the actual arbitration agreement. And the actual arbitration agreement can actually set forth the amount of discovery that a party can engage in, subject to the restriction being held unenforceable by the arbitrator because it is unconscionable. But unless your arbitrator holds that the discovery provision is unconscionable, you are bound by that reduced discovery. So, for example, there are arbitration agreements where inside the contract there is a discovery provision that might limit the number of depositions that can be taken. So, for example, in Superior Court, you have unlimited depots subject to a motion for a protective order. In arbitration, the contract can limit it to 3 depositions or even 1 deposition. On some employment arbitration rules, depending on who your provider is, there might be a limit on motion practice. So, for example, in court, everybody has a right to file a summary judgment adjudication motion, but some rules based on who your neutral arbitration platform is, might require you to ask permission from the arbitrator in order to file a dispositive motion. Why do these rules exist? They exist because the whole purpose of arbitration is to streamline the proceedings and to make it less expensive. And one of the ways we make it less expensive is by reducing the amount of law and motion practice and reducing the amount of discovery, short of a party challenging that provision as being unconscionable. So in some ways, the arbitration process is more informal. You can control somewhat the procedures, and you can even negotiate with the parties on the setting of the hearing dates. And so the parties actually have a little bit more control because there's less formality. And some arbitration rules require the arbitrator to issue an award under a certain deadline. For example, subject to a continuance, arbitrators should be issuing the award within 30 days after the arbitration has closed. And then finally, it is the judicial review of the arbitrator's award. And under the California Arbitration Act, there are very, very limited bases upon which a party can go to the Superior Court and ask that you vacate the arbitration award. And misapplication of the law is not a basis. You basically have to show fraud or misconduct or some degree of bias. And the same is with the Federal Arbitration Act as well. You have to show fraud, bias, misconduct. The FAA does have a section called manifest disregard of the law, but even the case law says that that manifest disregard of the law must be very obvious. So a slight misinterpretation of the law may not be enough. And with that said, however, if your arbitration agreement indicates that you can seek judicial review based on a misapplication of the law, then one can make the argument that you can actually seek judicial relief because your arbitrator did not apply the law correctly or did not cite the correct body of law.
All right. So before we take a deep dive into the process of starting an arbitration, this is just a little bit about what the general arbitration framework looks like. When you are in arbitration, you do have a couple of options. You can either choose an ADR provider, or your contract will have an ADR provider listed, the agreement or the language, or a stipulation, which we'll talk about later. We'll have an ADR provider listed, such as AAA, JAMS, Signature, Adjudicate West, ADR Services, among others. Or the parties can agree to an arbitrator and ask that arbitrator or person to conduct the arbitration ad hoc. That means they generally don't have to abide by a provider's rules. And most ADR providers provide some level of case management services. Typically, when you are reaching out to an arbitrator directly, they do not have necessarily a case manager. They may have, some legal support staff, but you will be working with that arbitrator on your own. Generally, that can create some issues. Providers within the state of California, especially, are very concerned about making sure the parties have the proper disclosures. There are very strict statutes and timelines within California under the CCP, which requires the arbitrators to make from especially as compared to other states, very lengthy disclosures about their relationships with the parties or the attorneys or any interactions with either of them. And it is, as Kristine said earlier, one of the ways in which a party can get an award vacated. And if you are doing it ad hoc, you may not have that same level of an arbitrator really making sure that those disclosures are accurate and always updated if necessary, if new counsel come in or anything like that, or a new party is added to the case. And then, Kristine, I know you talked briefly a little bit about the FAA and CAA, but if you want to talk a little bit more about that, and then FIHA.
Sure, yes, yes. So under the laws of arbitration, there are basically two bodies of law that govern the arbitration process. The first is the federal law, which is the Federal Arbitration Act. But California also has its own California Arbitration Act with its whole list of reported cases that have interpreted the California Arbitration Act. And the first thing you look at, well, one of the first things you look at, there are many things you look at when you look at the arbitration agreement, but if you're looking at the substance as to what area of law applies to your arbitration agreement, you look to see if the drafter indicated in there whether or not the FAA will apply with respect to the enforceability of the arbitration agreement itself. So in general, the FAA favors arbitration and makes arbitration agreements enforceable. The California Arbitration Act also governs arbitration, but it also has a whole body of law with respect to discovery and a whole body of law on substantive unconscionability as well as procedural unconscionability. And then, as I indicated, the two areas of law differ with respect to the grounds by which you can ask a court to vacate the arbitration award issued by the arbitrator. So, for example, under the CAA, you need to show fraud, misconduct, bias. But under the FAA, in addition to fraud, misconduct, and bias, you can also use a manifest disregard of the law, which is an additional element. However, that is a very, very high standard. So one of the things that one should consider when you're looking at the arbitration agreement is, number one, is the agreement actually enforceable? Is this a valid arbitration agreement? And to answer that question, you have to ask what area of law governs this agreement? Is it the Federal Arbitration Act or is it the California Arbitration Act? Because if it's the CAA, you would go to California law. If it's the FAA, you could go to the federal law. And if it is a claim under the Fair Employment and Housing Act, FEHA, one of the principal aspects of an agreement is that the agreement as a whole needs to be fair. So both the FAA and the CAA require the arbitration agreement to be fair. And that basically boils down to two types of fairness. There's something called procedural unconscionability, and the second is substantive unconscionability. And procedural unconscionability deals with the process by which the worker and the employer entered into the agreement. So the question you ask is, are the procedures or the process by which the worker signed the agreement, was it fair? Or in other words, was it unconscionable? So an example would be the employer knew that the employee did not speak, understand, or read English and was given an arbitration agreement and it was only in English, it was never translated. The employer knew the worker did not understand the agreement and told the employee, you have to sign this as a condition of employment, and they weren't given an opportunity to have it translated. So they signed a document and they were bound by a document that they did not understand. That would be an example of procedural unconscionability, right? In one ways, you can argue this agreement is so unfair that it should not be enforced. The second aspect is substantive unconscionability. So you look at the actual substance of this document and you ask yourself, is the substance so unfair, meaning it shocks your conscience, that it should not be enforced? So I'll give an extreme example. And maybe it's not extreme, it could be in some agreements. There's a discovery provision, and the discovery provision basically says that neither party can take any depositions, and they're not allowed to send any interrogatories, and they're not allowed to send any requests for production of documents. Basically, no discovery. That may be considered substantially unconscionable because you are forcing the opposing party to go prosecute a hearing without obtaining any discovery. And so if you bring a wrongful term claim, a discrimination, harassment, or retaliation claim, at a minimum, the process and the substance of the agreement needs to be fair. So those are some of the general preliminary issues that you would look at before you even start the arbitration process. You look at these procedural steps first.
All right. So we are going to assume that at this point, we are going to assume that the arbitration clause or a stipulation to arbitration is both procedurally and substantively not unconscionable, and that we are ready to proceed. So in the event you find yourself having to file an employment claim, or if you know that, an employee that of a company you represent will be filing an employment claim, this is how it gets started. So as we discussed earlier, arbitration is a creature of contract. So one way to get to arbitration is that there is a clause in the employment agreement that requires the arbitration of whatever the dispute is, because it is like we said earlier, there are some disputes that you're just not going to get into arbitration, or that the parties have agreed will go to court. Or you can, if you don't have a contract that requires arbitration and both parties agree to have to go to arbitration instead of going to court, you can stipulate post-dispute to arbitration. And then you would just submit most ADR providers, AAA included, have a submission form, and we have a demand form when there's a contract. The other part is that there is a court order. For whatever reason, a court has said, this dispute needs to go to court. Usually there was a discussion about an old contract and we don't have copies of it or something like that. The court can require the parties to arbitrate their dispute. So if once you know that you have to go to arbitration, you would fill out a simple demand form. They're usually located online of the ADR providers at the ADR providers website, pursuant to the different rule sets. So for us, it would be the employment rules. You would include either a copy of the arbitration clause from the contract, the stipulation where both parties have signed, yes, we want to arbitrate this matter, or a court order that requires the parties to arbitrate. And then you would also have to pay the appropriate fees to the provider. As we discussed earlier, for employees, it's a small fee and then a larger fee that needs to be paid to the administrator or ADR provider within 30 days. Or else then the claimant or the employee the employer will be deemed to have waived that, and the party can go back to court and ask the court to hear it instead of having to go to arbitration. And then once the ADR provider has received the filing, we do tend to get a few initial issues, not in every case, but we'll talk briefly about what some of the common initial issues that we get when we first have a case presented to us. So there are parallel court filings, ambiguous arbitration clauses, there's issues of confidentiality, and then there's the cost allocation. So Kristine is going to talk about the first three briefly, but for cost allocation, just know that the case law in this continues to change. So if you're an employment practitioner, you just want to make sure that you're up to date on all of the case law.
Okay, very good. So there could be instances in which there are parallel court filings. What that basically means is there was a filing. So you have one set of facts, one claimant, one respondent, or maybe more, and there are dual filing. So there could be a filing in arbitration, there could be a filing in superior court. And depending on the type of claim that exists, the parallel filings could be completely appropriate, or it could be not appropriate and one needs to close or one needs to be stayed to allow one to happen. But it would be very difficult to have a proceeding proceed on one set of claims in arbitration and then the same set in a court of law. And so at that point, one cannot begin the arbitration until the parties resolve these parallel court filings. So how could this possibly exist? It's basically an issue of law. So for example, like I indicated, you might have a plaintiff that files a representative PAGA action along with their own individual PAGA claim. So there are a lot of cases, such as Viking River and all the court cases after Viking River, that have held that you may compel arbitration of the plaintiff's own single paga claim for himself or herself. But those same Supreme Court cases do not allow arbitration of the representative claim or the class action claim. Therefore, a respondent, a defendant, might petition the Superior Court to compel the plaintiff to litigate his or her own single paga and wage and hour claim, and then stay the representative claim. Why are they staying it? Because the outcome of the arbitration might affect the representative paga claim. So it would not be appropriate to have both cases proceeding at the same time. So one of those cases might be stayed. Or you have a case where a matter was filed in Superior Court and one party filed a petition to compel arbitration, and the other party is objecting to it. And then somehow the arbitration, which moves at a faster timeline, is moving more quickly than, let's say, the Superior Court, which is now engaged in civil law and motion proceedings. And based on the court's calendar, you're not getting a hearing date to resolve some issues. So if you have these parallel filings, it is important to bring it up with the arbitrator at the first instance so that these issues can be resolved as quickly as possible so that both legal proceedings can go in the right timeline. So you want to address the parallel court filings quickly. You also, at the preliminary stage, want to address ambiguous arbitration clauses. And as I'll defer some of it when you start talking about the preliminary hearing, but it's at the preliminary hearing where ambiguous arbitration clauses might become an issue, and it really deals with discovery, the scope of discovery, dispositive motions, for example, or even the choice of law. And so those are issues that you're going to have to bring up in the preliminary hearing.
All right. So we have a demand that has been filed, and it is now in front of, the case manager. At this point, we are assuming that you chose an ADR provider and you're not doing ad hoc. The ADR provider's case manager will have received your contract, your demand, and any subsequent, or court orders attached or pleadings or anything like that at the beginning stages. And the case manager will review the case file and look to see if there is something laid out in the clause about how to select the arbitrator. So sometimes a contract clause calls for 3 arbitrators. Sometimes it calls for a single arbitrator. That will be, something the parties can agree. If the parties agree to have a single arbitrator hear the case, and the contract clause calls for 3 arbitrators, then you can certainly let your case manager know, and we would just appoint a single arbitrator. And it does tend to be much cheaper. I believe it's 5 times more expensive to have a panel hear a case than it is to have a single arbitrator hear a case. If the arbitration clause is silent, if it doesn't lay out a process for the provider to follow in terms of how the parties are supposed to select an arbitrator, or it defers to that ADR provider's rules, then we will follow our rules. And for AAA, there's a couple of things you can do. We generally will send out a rank and strike list. The arbitrators on our panel, in order to be on our panel, they have to have 50% of their practice before they join the panel, or even during, be devoted to employment matters. So these are arbitrators who have the necessary expertise to hear an employment case, because it is a different type of law and it's very nuanced. And we want the arbitrators to continually be up to date on the newest case law, because they're going to have to apply it. we will send out a list of 14 arbitrators. I'm sorry, a list of about 10 arbitrators or more, depending on how many arbitrators we need to select. Um, and generally, it will be arbitrators from the location the hearing is supposed to be in. So let's say your contract says that any hearings that will take place in Los Angeles, then the arbitrators, at least on the very first list, will generally be from the Los Angeles area. They will be on the employment panel, and the parties will have 2 weeks, pursuant to our rules, to either mutually agree on an arbitrator, which we always think is best, but we know is not something that can happen in every case. So they can either by mutually agreeing on an arbitrator and then letting the case manager know this is the person that we want. Or if you know that you're just not going to get mutual agreement or you can't, then you rank and strike. So you strike the arbitrators you don't want and you rank the rest, and then the provider chooses, or we invite the most mutually agreeable arbitrator based on those two lists. Each side, giving us their feedback. The What we try not to do is select an arbitrator for you. The selection of the arbitrator is probably the most important decision you're making early on in your case. And it's one of the things that sets arbitration apart from going to court. So we try not to. And it's usually a very last resort. We've sent multiple lists. I'm not talking just one or two, I'm talking 3 or 4 lists. We've had to maybe even move outside of Southern California. Now we're in the Bay Area, or sometimes we're out of California altogether because we cannot get you a list of arbitrators that you can agree on. Um, in order to make sure that the case continues to proceed, we will select an arbitrator, but nobody wants to do that for you. We want the parties to have a say in this really important decision. Um, so that's what arbitrator selection can look like. And then we did discuss the kinds of disclosures that will need to be sent to the parties prior to the arbitrator doing any work on your case. And it's, I want to say in California, like 28 or 30 questions about your, have you ever worked for any of the parties? Have you ever worked with them? Do you have any relationship with them? And then the same for all of the representatives, for the attorneys. Or have you ever arbitrated a case? Were you an arbitrator for anybody in this matter? And then the arbitrator has to disclose that as well. All right. So now, Kristine, we've selected an arbitrator and you're at the preliminary hearing. So Kristine is an arbitrator on our panel. So I'm going to let you discuss what the preliminary hearing looks like and any tips or tricks at this stage that you want to give the attorneys on the webinar.
Great. Yes, thank you. Thank you, Stephanie. So you're at that stage now. You selected your arbitrator, and the next step is that the case manager will coordinate a date and time that is available for all parties, meaning the claimant, the respondent, as well as the arbitrator, to set up the first preliminary hearing. And once you secure that date and time, the arbitrator might have a template proposed, let's say, status conference form, the same type of status conference form that you might see in a court of law that you need to file a few days before your first status conference. Except in arbitration, the form is a little bit more detailed because the parties have opportunities to really negotiate and agree to a lot of the process. And so, for example, prior to the preliminary hearing, when the two parties meet and confer to fill out their joint status conference report, they get to decide, when would you like this hearing? And actually, sometimes I see parties disagree as to when they want this hearing. They actually disagree as to the length of the hearing, and then they disagree as to the location of the hearing. In which case, that is at the preliminary hearing conference, I will listen to the relative concerns and issues of both sides, and then I would need to decide on the hearing date, the length of the hearing and the location. And sometimes there's a dispute between whether or not they want it done remotely, or they want a hybrid, or they want all of it in live. So those are issues that your arbitrator will have to resolve if the parties cannot agree amongst themselves. Another issue that the parties can agree to that is really important is the extent of discovery. So unlike a court of law where you just follow the Code of Civil Procedure or the Federal Rules of Civil Procedure, the parties, the first thing they should look at is the arbitration agreement. And you're looking to see if there's a limitation on discovery. So I gave you the example of an arbitration provision that basically said you can't do any discovery at all. Well, if that were the case, the unhappy party might put in the joint status conference report that they're going to challenge that provision right away. So you really can't even set a hearing date if one of the parties is already challenging something that affects the process itself. Or they might, arbitration contract might have a limitation of discovery. Let's say they're limited to 2 depositions, but one party feels that they need to take 15 depositions. And they might tell me that. They said, look, we will agree to a limitation on discovery, but the limit is 15 depositions plus an expert witness. And if there's a dispute on that, I would need to resolve that issue. There might be issues about dispositive motions. One side might not, they might limit the ability to do a dispositive motion. Once again, you look at your arbitration agreement. Does it indicate that you have a right to file a dispositive motion? And so you want to consider your arbitration agreement as your scheduling order in terms of your discovery and your motion. You're also looking at your pre-hearing briefs and whether or not the parties intend to engage in mediation or have settlement discussions. You might want to let the arbitrator know because they will be setting your hearing date. Another issue that's really important is the type of an award you want the arbitrator to render. So in employment cases, the rules of your arbitration provider might indicate that the arbitrator has to grant a reasoned award, meaning there are reasons behind the decision. But if the parties do not want a reason behind the decision, what you'll get is an award, but with no explanation, which means it will be harder to challenge that award decision if you don't even understand the reasoning, especially under the FAA, where the basis for vacatur is a manifest disregard of the law. The parties will also agree on whether or not they want a court reporter. Some arbitrations, the parties don't want a court reporter. They don't believe that the amount at issue is enough to justify a court reporter. And then you'll have to have a meet and confer as to how you would like to present your exhibits and your binders. So I've had cases where the respondents' counsel and the claimants' counsel have worked with each other sufficiently before they even appeared before me that they've already said, we already have an exhibit binder and we've already stipulated to it. And here it is. And I open it up and it's, 1,000 exhibits and they've already stipulated to it and they're already pre-marked, which is great. And you might have parties where they disagree, in which case we need to talk about how we're going to lay out our exhibits. And then finally, of course, some housekeeping matters, the formality. So this is an interesting issue because arbitration is actually a very informal process, but it's not so informal that the way we address people is relaxed. So you want to address your arbitrator and your opposing counsel with the respective titles because you do want a certain amount of decorum and respect. I've seen instances where the attorneys they start engaging in a lot of bickering and fighting in front of me, and part of managing that is to really manage the formality of the process. That even though it's less formal, it is a litigation forum, and that all counsel and the parties, your respective clients, need to respect that this is a formal litigation process to a certain degree.
All right. So I think we covered a lot of the discovery and scheduling issues in the previous slide, but if there's anything on here that you want to go over, Kristine, let me know. But just some ADR, just very briefly, some ADR providers do have discovery protocols. I know ours are listed on the AAA's website for FLSA and then non-FLSA cases, Fair Labor Standards Act. But let me know if there's anything else on here that you want to point out, because I do have a question for you, Kristine, as
Okay,
well.
sure. I think this is pretty significant because your arbitrator provider platform, whatever it is, there's a lot of different providers out there. They all have their own rules. And they might have rules on discovery. So some arbitration platform provider has something called an initial disclosure, which is similar to Rule 26 and now the Code of Civil Procedure, where the parties engage in an initial disclosure of documents. And I asked the parties if they would like to agree to the discovery rules of the arbitration provider platform. And if they do, I set a deadline for that initial disclosure of documents. And the purpose for that is to streamline your discovery such that the parties will disclose documents that are relevant. And I'll just give you an example. In a wage and hour case, if you're doing an initial disclosure, most attorneys know what you are supposed to be disclosing, and you disclose it, and you save time. And what I do is I set a deadline. So I give time for the parties to get their claims settled and to give them time to compile their documents, to bait stamp them, and to get them to the other side. And once I set that deadline, they can then review it and then they can follow up with traditional discovery. But once you get everything, you might not need as much formal discovery. If you're not willing to agree to it and your arbitration agreement is silent, then the default would be the Code of Civil Procedure, absent an agreement by the parties. So the first thing you want to consider before your first preliminary conference with the arbitrator is to read um, the rules of the provider organization and see if they have any process for discovery. And if it's something that you believe is helpful for your case, then during your meet and confer, you can propose to the opposing counsel that you would like to follow the provider organization discovery tools. And then the last, of course, is will the arbitration agreement limit discovery? Absolutely. There are many provisions where the drafter has limited discovery. Um, just be careful that if it's too limited, it can be considered substantively unconscionable, in which case the party that is not happy or challenging that provision will inform the arbitrator that they need to address this issue first. And then that would trigger a law in motion briefing schedule and a hearing to address the preliminary aspects of arbitration before you get started.
All right. Kristine, can you talk to us about the alternative methods for presenting evidence in arbitration and how it differs from court? For this is we're at the stage now where everybody has gotten the discovery that they've needed, or we're ready to at least proceed to the evidentiary hearing, which is what it akin to a trial. So, Kristine, as an arbitrator, can you talk to us about that?
Yes, yes. Thank you, Stephanie. So the great thing about arbitration is because the parties have a little bit more control of the process, they can actually decide how they would like to litigate their case. That's very different from a court of law where you have to follow very strict deadlines and timelines set forth under the Code of Civil Procedure. So, for example, I've had cases where the parties want a desk arbitration. So what's a desk arbitration? They want to save time and they want to conserve their financial resources. So they have waived oral arguments. They don't want a hearing. They rather just submit briefs with exhibits and declaration. And they want an award or a decision based on a briefing schedule. And what's interesting about that is they might even agree that we don't even need to lay the foundation for admissibility. The parties agree that these documents are the actual genuine documents. We're not going to lay the foundation, that this section of the depot transcript, assume that it's true, there's no contrary testimony, and ask the arbitrator, render an award based on this. The other thing that's interesting about arbitration is the arbitrator can rely on case law outside of your jurisdiction. So it's very frequent that the parties are citing cases not only outside of our jurisdiction, but they're also relying on previous awards, opinion letters, etc., to use as persuasive authority. And they're asking the arbitrator to consider that. If you do decide to have a physical hearing, it could be anywhere. It could be in the law office conference room. It could be at your arbitrator provider organization. And when you show up, you're going to get a conference room at a conference table. So it's not going to look like a courtroom. But for all intents and purposes, you do need to set forth testimony, and you will have a court reporter if the parties agree to it. And the conduct of the proceedings are a little bit more informal, but the burdens of proof are still the same. The claimant has the burden of proof based on the type of claim that they're proceeding with, and the respondent can still move forward with their alternative defenses. The other great aspect of it is the parties can agree to a fully remote hearing, or they can agree to a hybrid. And oftentimes the parties might disagree. One side might want a fully remote hearing, the other side might want a in-person hearing, in which case the parties might agree to a hybrid hearing where it's physical in person, but any witness, they have the option of appearing remotely. So there's very, very different ways, and you can be very creative as to how you would like to have that hearing. And part of it is you go back to the philosophy of arbitrations, which is efficiency. And it's basically your case. This is your contract, and the arbitrator will give some deference and will consider alternative methods of putting on that evidence.
All right. So now we've had our hearing, and the arbitrator is, we're in the post-hearing phase of the case. We have, as I stated earlier, this is not something every case will have. It really is case dependent and arbitrator and party dependent. But in the event there are post-hearing briefs, a deadline will be set. Very rarely is additional hearing or argument needed. And the post-hearing briefing is not a time to raise new arguments. It's not a time to present new evidence. It usually is just more a rehashing and pointing out to the arbitrator or panel of arbitrators the highlights of your case, why your claim is correct, why the law is in your favor. And once that is all done and the arbitrator or arbitrator feels she has all of the information she needs to make her decision, she will close the hearings. That's usually just done either in an email to the case manager or to the parties to let them know I'm no longer taking any more information. The hearings are closed, and I will be issuing my award within 30 days. Very rarely do arbitrators need longer. Sometimes I'll have to reopen it if there is something in the record that doesn't make sense, or if they'll wait to close the hearings until all the transcripts are in, if there was a court reporter that was present at the hearing, because you want to make sure all the transcripts are in, and generally the parties want those transcripts as well so they can write their post-hearing briefs. In arbitration, there are generally deadlines for awards. So like I said, the AAA has a 30-day deadline after the hearings have closed. The award will address or should address every single claim that was made by either party. So sometimes in employment arbitration, you will have counterclaims. But all of those need to be addressed within the award. And if there is an interim award, which is when the arbitrator lets everyone know who the prevailing party is, and then we go through the attorney's fees, which we didn't go into here because that could probably be its own hour-long CLE. then the final award will be rendered to the parties. A common question is, can you appeal to the arbitrator? No. The arbitrator under the AAA's employment rules a party can ask for a modification of the award to clarify if there's a typographical error or a numerical, the numbers aren't adding up, but it doesn't change who the prevailing party was. You can do that within a short amount of time after the hearing or after the award has been rendered. But once the arbitrator has rendered their final award, she no longer has jurisdiction over that case or the parties. Enforcement and appeal of any award will have to go to state or federal court, depending on if it's under the CAA or the FAA. And then really quickly, because I know we're running out of time, just wanted to give Kristine a chance to talk about pitfalls to avoid from her perspective as an arbitrator.
Okay, thank you, Stephanie. So one of the things you're going to look at, of course, is the arbitration agreements itself, and if it's vague, and it's vague on a particular issue, that's when you raise it during your preliminary hearing if you need resolution by the arbitrator, if you can't get an agreement by counsel. The other issue is poor communication and cooperation between counsel. If the attorneys are not getting along, then it's going to result in more law in motion and more discovery disputes, and that really just results in a more expensive arbitration. And so you want to be able to streamline that process. If there are discovery disputes, you have to look at proportionality. So unlike maybe a court of law, an arbitrator might put on a fairness hat to say, well, based on the discovery that you're seeking, let's look at the types of claims that you are trying to prosecute. So, for example, if a discovery provision has a limitation on depositions and one side is challenging that, I might look at the type of claim that's involved and ask, well, is it sufficient, or is the case so complex that that discovery provision is unconscionable because it really limits the party's ability to prepare the case and to secure the information that they need. It's really important that once the deadlines are set by the arbitrator, that you respect the deadlines and to follow the process. Even though it's an informal process, the whole goal is to process it efficiently, and you don't want to wait on doing your discovery because that will affect the ability to have a hearing. So the overarching principle is to allow this process to go smoothly, to make it as efficient as possible. And the way we do that is we have more discretion, and we're not necessarily bound by the Code of Civil Procedure or the Federal Rules of Civil Procedure, and we can streamline the case more easily than if you were not in arbitration. And then finally, of course, it's always more pleasant when everybody is professional throughout the entire process. Your representative parties, it's a more pleasant process for them. It's a more pleasant process for the attorneys, of course. And it really helps the whole process in terms of being able to maintain fairness and efficiency.
All right, so that's it for the presentation. I know we're at time. So it looks like we have a few questions. I don't know if we'll be able to get through all of them. It looks like there are some for you, Kristine. So the first one is, as discovery is the bane of litigation, sometimes leveraged to compel settlement, do you have proposed limits that have sustained liberal discovery scrutiny?
So thank you for that question. If one of the parties believes that the discovery process is being abused, and let me back up. You look at your arbitration agreement. If there are no limits on discovery, and the parties never agree to a limitation on discovery, you would default to the CCP. The great thing about arbitration is if a party believes that discovery is being exploited or being utilized for some other means other than to obtain the information, you have the ability to ask for a discovery conference with the arbitrator. and ask the arbitrator, can you please limit the discovery because it is not, what do you call it? It does not lead to the discovery of admissible evidence, and it's not relevant, and it doesn't even relate to the claims that are being litigated. And the arbitrator can consider that. And that's the beauty, is that they can put a limit on discovery. It may not even be harassing. It is simply too much for the type of claims that you are prosecuting. And you can ask the arbitrator to put a limit on that.
And the next question is, in case an award is without reason, but there is some substantive and conscionable element in it, can it still be challenged?
Yes, thanks for that question, Ms. Rana. So the whole concept of substantive unconscionability goes back to the arbitration contract, and that leads to lack of enforceability. And there's a whole body of case law on what is considered unconscionable. And when you're looking, even before your first preliminary hearing, when you look at the agreement, and if you believe that the agreement should not be enforced because it's unconscionable, that's one of the first things you raise with the arbitrator so that you can discuss the lack of enforcement if you believe it is the case, such that the arbitrator will have to make a decision as to whether or not to set a briefing schedule or to take some other action. But once the award is written, that assumes that you've agreed to the entire discovery process, you've agreed to the litigation process. Um, Substantive unconscionability is not a basis for vacating an arbitration award under the FAA or the CAA.
And so I'm going to go to another question about that, and then we'll get back to Seth Spiewak's question. But if the plaintiff files in court because she believes the arbitration is unconscionable, why can't they have the court decide the issue instead of an arbitrator?
So that is, thank you for the question, Ms. Fujiwara. Was it Fujiwara?
Fujiwara?
There's a whole body of case law right on that very, very issue. And the issue that you've just addressed is a legal issue, and the legal issue is who decides the enforceability of the arbitration agreement? Is it a judge or is it the arbitrator? And it really depends on the language of the arbitration agreement. And so you always go back to what was written in the arbitration agreement with respect to jurisdiction and deciding enforceability. But it is a very complex area of law. But either outcome is actually feasible. It could either be the arbitrator or the judge, depending on how the agreement was written. So I think the overarching theme you've been hearing is the drafter of the arbitration agreement, when they draft it, needs to be very clear, very unambiguous, and very thorough and comprehensive in order for it, it helps with enforceability.
And then Ms. Spiewak asked, what is the typical use of initial discovery protocols for employment arbitration cases? Are they presumptively applicable and effective to make the parties exchange basic discovery early on without requests, like the initial disclosures in federal court? What actually typically happens? So what do you see in your cases actually happen?
Yes, thank you, Mr. Spiewak. So first of all, the parties need to agree to the initial discovery disclosures in the employment arbitration rules. So number one, look at your arbitration agreement and then look for a section on discovery and ask yourself, does this agreement limit my discovery in any way? And if the answer is yes, then you can ask yourself, well, is it a reasonable limitation or is it an unreasonable limitation? If it's unreasonable, you could challenge that. If it's reasonable, like if it says either side can take up to 20 depositions and it's a small 5-employee coffee shop, 20 is reasonable because there's only 5 employees. So there would be no reason to challenge it. That should govern. And then in addition to that, during your meet and confer with the attorney, you can agree to the discovery protocols and the arbitration rules. And if both lawyers agree to the discovery protocols, then you would do an initial disclosure. What's the advantage of an initial disclosure? The advantage is you get the documents right away, or at least based on the timeline that the arbitrator sets, and you don't have to do a request for production of documents. So it saves you time in checking off the boxes, in drafting the RTP, and it saves the other side time in responding to an RTP. Either side or both sides just look at what they believe is relevant. They collect the documents, they bait stamp it, and they can email it to the other side. So you save both sides a lot of time. Now, at that point, if you still believe that there's additional discovery that you want, you can then send out a request for production of documents if your arbitration agreement allows it to. If it doesn't, and you feel the need for it, you have the option of asking the arbitrator for intervention.
Okay. All right. It looks like Seth sent a link. Thank you for that. That is so Sandra, if you want to email me directly, I can try and help you with that. I'm not sure it there might be procedural issues that haven't taken place yet. I couldn't answer that directly yet, but please email me. And I'm more than happy to help. And if anybody else has any questions, either, live or if you're watching this recorded, please email me. If they're for Kristine, I can direct them to her. But we really appreciate everyone's time here today. Thank you so much.
Yes, thank you.